follows him, that's the worry. So yeah, I'm not sure where Lord Lloyd Jones is. It's kind of difficult to know, but he's not doing the same kind of reasoning from first principles. Okay, so there's kind of that element of it as well. Okay, the second point I want to see these cases as illustrating is this aspect of using statutes in a different way. And Privacy International illustrates that really clearly when we look at the differences between Lord Carnworth, Lord Lloyd Jones, and Lord Sumption. So, Lord Carnworth is looking at a piece of legislation and he's saying, okay, I've got an ouster clause. Now, I know there's a general presumption against ouster clauses in English law. And not only is there a general presumption against ouster clauses in English law, but this is going to apply equally to an ouster clause over a judicial body as it is to an ouster clause over a body that is not performing a judicial function. Okay? So it's the same in both. There's no distinction to my presumption depending on whether this is a body performing a judicial function or a body performing an administrative function. Okay? When I go away and look at the legislation, the way in which I use this presumption is another illustration of the principle of legality. This element of there are fundamental principles that Parliament would not have wanted to erode, and so I'm going to look at general words and say they don't allow me to do this. So you're kind of drawing on background constitutional principles and then using those to help you work out how you go and interpret the legislation. You look at the ouster clause and you say, oh, I've got this general presumption, so because there is this general presumption, are there sufficiently clear and precise words to make sure that you're removing judicial review here? No. If you'd wanted to remove judicial review for errors of law of Parliament, you would have said so. In very clear and precise words, you wouldn't have just said including jurisdictional errors, you'd have said including any error, legal error, factual error, error with whether you had a packet of crisps this morning, don't care. Any possible error under the sun ever invented ever has been removed from the court. It's not clear enough. So because you haven't included this element of what if you made a legal mistake as to whether you had jurisdiction, then you haven't given me sufficiently clear and precise words. I can read it down, no ouster of jurisdiction. Okay? Lord Lloyd Jones does think there is a general presumption when you're looking at ouster clauses, but only ouster clauses over administrative functions, not judicial functions. Nevertheless, even without the presumption operating, he doesn't think the words are clear enough because not all jurisdictional errors are legal errors, and so therefore you might make a legal error as to whether you had jurisdiction. You still might, if you make a factual error as to whether you had jurisdiction, then it would have been removed, but not a legal error. It's not clear enough they wanted to remove legal errors in the wording, and that's as far as he goes. Unsurprisingly, Lord Sumption also does not think there is a general presumption against ouster clauses when it's ouster clauses over judicial functions. But what is interesting is how he answers the question on this ouster clause. He goes away and says, I've got a big piece of legislation here. And this big piece of legislation is telling me what the powers of the Investigative Power Tribunal actually are. So I'm going to go away and read them, because then I'll know what powers Parliament has given to the IPT. And when I go away and read this, I will get an understanding of what Parliament wanted the IPT to do. And that's then going to help me understand whether you can oust this jurisdiction or not. And when I look at this statute, it's very clear that what Parliament wanted the IPT to do was to have the authority to substantively make legal determinations. That's its job. That's why it's got the composition it has, that's why it's got the powers it has, that's why it's got all these kind of responsibilities in the Human Rights Act. So, given that, Parliament doesn't mind if it makes a mistake with regard to the substantive determinations of the law, and it's removed the jurisdiction from that, but it will mind if it gets it wrong in other areas, when there's the process aspects of the law that I talked about, the Leon Asher Baker's context. And that's so, it's not so much that he's got a different conclusion, it's how he gets there. I'm not going to go away and say, here are some presumptions, let's look at the law, does the statute stop me? Instead, you're saying, let's look at the statute, and from that, it's going to help me understand what the outside clause is supposed to do. So I'm saying the opposite way around. And that's illustrating how in some of these big key constitutional cases, you can see a move away from thinking about statutory backgrounds and more towards thinking about constitutional principles and then looking at statute. Because you can see this tension in the way in which they're reasoning. And it's also a tension in what we think about the principle of legality, which is where Miller-Cherry comes in. Because Miller-Cherry is nothing to do with statutes. It's a prerogative power. Okay? But nevertheless, we're reading down the scope of the prerogative power. And you might think, well, that kind of looks like what we do with the principle of legality. We look at statutes, we look at background constitutional principles, and we'll read down broad words to make sure they don't undermine these fundamental principles. Are they doing something similar in Miller-Cherry? I can find a paragraph for you. The answer is sort of. Because they don't say this is an application of the principle of legality, but nevertheless, they start mentioning how it's of some assistance to consider the case law to do with the principle of legality, like unison. So it's not the same, but we can be assisted by these cases. It's a bit like saying, well, if we can do this with statute, then surely we can do this with common law powers too, and we can draw some assistance from these cases as to how it operates. So it's a similar kind of idea. Fundamental principles used to read down legislations, fundamental principles used to read down prerogative powers. And in case you're wondering where the assistance comes from, find it's paragraph 49 in Miller-Cherry 2, where you get a wonderful reference to assistance from these cases like unison that apply the principle of legality. So again, it's kind of almost reversing. It's almost like the statute is a brake on your fundamental principles rather than the statute dictating outcomes. Okay? So we've got those elements of differences in constitutional reasoning. We've got these elements of differences in judicial reasoning, how they use cases, and how they use statutes. My third feature was this idea of moving away from individual rights towards constitutional structures. So what do I mean by this? It's almost like a latent understanding of the separation of powers, helping them to work out how you divvy up powers between different institutions. So if you go back to Privacy International, you've got an element of how far can the courts control the executive, because technically these tribunals are part of the administration. But they're like courts. And they're looking at the institutional features and trying to think about what kind of check should we have over them. And in Lord Carnwath's judgment, as well as all these differences about different assumptions, there's also this different aspect of thinking about what this body is doing. And he recognises that it's a judicial body, he recognises that it made judicial determinations, but he's concerned about different little islands or pockets of law. What if the IPT makes a determination of the meaning of the statute? Okay, great, it determines what the IPT does, but if other bodies were also interpreting the same statute, there could be judicial review decisions to come up with a uniform understanding of what the law means. That's going to kind of check on that. We can't have the IPT, kind of, little IPT island law, where it's all very different, and the IPT has different interpretations of statutes that are then interpreted differently by other courts in different ways. So we need the judicial review to check that and have this kind of element of certainty and uniformity and making sure all of them adhere to the law. Because the decisions don't just affect these. They don't just affect the IPT, they can affect others. So we need that kind of check. And it's kind of trying to get an understanding of how the institution is working as a whole when thinking about how far can the courts check it. So this is kind of almost like institutional sense going on about how these different institutions of the Constitution interact. So it's not just this kind of just rule of law, just fundamental rights. It's reading it in that institutional understanding as well. If you look at Miller-Cherry, my reading of it is this is the courts coming in and saying, how do I get a good institutional balance between the government and the legislature? This is the government that has used its powers to remove the legislature. So the legislature can't hold the government to account. It can't scrutinise its legislation because it's not there. It's been prorogued. It's on holiday. It's not looking at all these pieces of legislation to perform its function anymore. It's essentially stopped. And all the pieces of legislation during that session have stopped unless they've been able to be rolled over. There are no committees, there's nobody to scrutinise, nothing's going on. So it's trying to say, well, when is it legitimate for the government to be able to do that? And there are legitimate circumstances, but sometimes, and most of the time, prorogation is fine, just to create a new session. But sometimes there can be instances where it goes awry and is too far, starts to undermine these fundamental constitutional principles. When it reaches those extreme, exceptional circumstances, then we, the courts, will intervene. And they're intervening to protect that balance between the government and the legislature, to make sure those fundamentals are in place within the institutions. So I don't just read it as it's there about promoting the rule of law or promoting democracy. I think it's also thinking about how do we get the balance right between the institutions. I think this is starting to influence these key constitutional decisions. They're not just thinking about how do we protect individual rights, they're thinking about how do we protect the fundamental structures of the UK Constitution. Okay, so hopefully I've persuaded you there are these features, and this is where you might start arguing with me, so I'll try my best. So I'll just say it's justified and leave and see what you say. I think it can be justified, but I can understand the criticisms. So is this a move in the right directions? And if you've gone away and read anything on the Judicial Power Project website, you'll realise there's lots of criticisms about the way the courts are moving in this direction. Is it legitimate for them to do so? They're not democratically elected. They're not democratically accountable. They're deciding key constitutional principles that have huge ramifications, not just for the structure of the Constitution, but political. So there are huge political consequences of the decisions they took. Even though they took them on legal issues, there are these political ramifications. So should courts be intervening in this way? And if Parliament has said, there's no judicial review here, can courts turn around and say, yes, I think you find there is? Are you going too far in the way in which they're interpreting legislation enacted by a democratically accountable body? And it's not just this element of these aspects, it's also the aspects of how we're informally changing these constitutional structures. To the extent that we're starting to change them, is it legitimate for the court to have a role in changing the Constitution? And this is where I get to plug Mike's magnificent blog post, in which he's looking sceptical. It is magnificent, it's not just the alliteration. But it's looking at and questioning the way in which courts are developing these constitutional principles. Because the Constitution is changing, and it's not just it's just one institution doing this, so there isn't necessarily input from other institutions of the Constitution, but the normal citizens who normally expect to have a role in constituent power just watch it. They watch it on the television and they protest outside the Supreme Court, but they don't have any say and they don't have any input into what is going on. And it's not just a lack of legitimacy, but there's also a lack of joined-up thinking. So you have a different case that will do something, and it's not just the cases that are doing this, but random pieces of statute goes away and do this. So the lovely Fixed-Term Parliament Act, who's got a short life. I'm not sure when it's going to be repealed, but it's the Queen's speech says it's going to be repealed. But that had all sorts of knock-on constitutional ramifications that I don't think anyone thought about when they enacted the legislation. Or the other favourite one, let's go away and modify how we interpret Standing Order 24. Because if we modify how we interpret Standing Order 24, that will then allow us to go away and use Standing Order 24 to modify and suspend Standing Order 14, and we can then push through pieces of private members' bill we might otherwise not be able to do. That has radical consequences for the Constitution, but it's decided within the House of Commons. So all these consequences, they can have all sorts of knock-on ramifications later on, and there's no necessarily interinstitutional balancing, there's no role of the people, and sometimes it can be so unclear how far can they actually perform their constitutional function if we don't know what the rules are, and we're having to change them, they're constantly modifying and changing. So I can understand the criticisms and the problems. But nevertheless, I'd like to argue that if limited to extreme circumstances, this is legitimate. And it's understanding the context of these two cases. these cases are undermining the balance of power. And it's normally because the government or executive has done something that makes it harder for it to be held in check by either the courts or by the legislature. And in those circumstances, I think it can be more legitimate for the courts to be intervening to protect these constitutional structures. And I think what they're trying to do is not necessarily modify or change the constitution, but recognising that in the UK's uncodified constitution, with parliamentary sovereignty, where we don't distinguish between constituent power and normal, ordinary lawmaking power, then we're relying on the kind of subtle checks and balances going on in the background to try and make it legitimate in some sense. And so I think it's legitimate for the court to be protecting that when we are still in the constitution we have, uncodified with parliamentary sovereignty. So if I look at Miller-Cherry, I would say, okay, do we have a circumstance in which this looks as if it's legitimate for the court to intervene? And I would say it is legitimate because of the specific exceptional circumstances it was dealing with. You had the long restriction. It had severe constitutional, social, political ramifications for having prorogation for so long. It was at a time when Parliament was meant to have a say under Section 13 of the European Union Withdrawal Act 2018, but wouldn't, because it wouldn't be there. As you run up to a deadline that only can be modified with agreement between the government and someone else. You can't unilaterally modify this deadline. The deadline is there, someone else has to agree with you to change it. And all those circumstances combine to make it quite exceptional to not allow the legislature to act in those circumstances. I think if you're dealing with these exceptional circumstances, and when the court is intervening in a way that is not going to enhance the powers of the court, but is predominantly there to help balance the structure between the legislature and the government, I think it can be legitimate for the court to intervene in those kinds of cases. And I see with Miller-Cherry as legitimate, despite all of these aspects of reasoning down this big way. With Privacy International, I'm kind of probably more with Lord Jones. It's kind of an odd. I kind of partly agree and partly disagree with all of them, just to be annoying. But I think what is legitimate there is they're thinking about, again, the structures. So to the extent you're thinking about when is it legitimate for the legislature to remove control of the courts over executive bodies that are part of the administration, then again, I think the courts need to be clear and precise, and I think it's justified for them to read things perhaps from first principles more broadly in those circumstances in order to make sure you've got a proper check and balance going on so the courts are performing their proper constitutional role as currently designed at the time. And I'd like to suggest in conclusion that not only does this move in the right direction, but if you get it wrong, the legislature will push back. So there is another check, and sometimes the legislature will push back too far. I give you Section 26 of the European Union Withdrawal Agreement Act 2020. If you've not read it, you should. It was described in the House of Lords by Lord Howarth as petulant. Okay? It's a petulant response of the government to what the courts have been doing. That was his description of it. So I can say that because it's in Hansard. So you can go away and look it up. Because it was seen as a breach of the separation of powers and a breach of the independence of the judiciary. What the clause does is it empowers a minister by regulation to say that certain courts other than the Supreme Court will not need to be bound by precedents of the Court of Justice of the European Union post-Privilege Day. It will also tell them the criteria they need to use to decide not to be bound. It can also tell the Supreme Court the criteria to use to decide not to be bound itself, because the Supreme Court is already not bound by the European Withdrawal Act. In other words, it's kind of saying, okay, courts, there are these precedents, but we'll tell you when you can ignore them, and we'll tell you what the criteria are that you can use when you decide whether to ignore them or not. Don't worry. They will be consulting Lord Reid, the President of the Supreme Court, and the various other members of the Lord Chief Justice, and various will be consulted beforehand. And there is a sunset clause. They can only do this up to the end of this year, but obviously the things they've set will apply beyond then, but that's there too. Okay, so So there is a sunset clause, and they do have to consult. So the question is, what are you going to do with this power? And we won't know until we see the regulations, and then we'll get an understanding of what these instructions are going to be. So if you ask me, what do I think Miller 3 is going to be, I think Miller 3 is going to be a challenge to one of these regulations that tell the courts when they're not bound by decisions of the Court of Justice of the European Union. Why? Because it's also starting to undermine the separation of powers and undermining the checks and balances mechanism. I don't know what the answer will be, because I don't know what the delegated legislation is going to be, and that's going to be key. But the fact that it is there shows you that there are other checks and balances mechanisms if the court goes too far, but I think it also shows you the importance of getting the balance between the different institutions right. I'm going to stop now because I'm very tired. Thank you very much for listening.
Thank you very much, Alison. Mike?
Thank you. Thank you, Alison. That was absolutely fascinating. And particularly in relation to Privacy International, which is an absolute mess, thrown so much for me to think about again in relation to that case, because it's been a while since I've looked at it. So thank you for that in particular. There's so much to discuss here that I'll sort of try and limit myself a little bit, because honestly I could talk for ages, but I won't, because that'll give people a chance to comment as well. I mean, I think we were joking about whether we agree about anything. I mean, I completely agree about your diagnosis of the current position. I think very clearly you must be right about the absolutely fundamental and profound change in practice that's going on in the UK Supreme Court at the moment, which I think is very difficult to kind of quantify, and I don't exactly know how you would do it in empirical terms. It's something I was thinking about. I'm sure there are people who sort of do sort of discourse analysis who could do it. But just looking back at the kind of the cases we've had in the last 10 years and reading them against, you know, what we would have considered the big constitutional hitters from the previous eras to be, you know, Factor 10 and the Home Office, they never talk about the Constitution in those cases at all. They never mention it. They kind of, you can count on one hand in most of those cases the number of times they talk about the Constitution, a constitutional principle, or anything else. The language is just not there. And it's fascinating that it is now not just present in a very, very prominent way in these cases, but also meaningfully present in the ways that you have explained so clearly, that they are using constitutional ideas as sort of the, you know, they're almost skipping out the law in a lot of cases and kind of going straight to the principles and going, how are we going to use these principles to resolve things? So that kind of change in practice, I think, is hugely significant, and I think under discussed. But that's possibly because it's still going on, and we're kind of in the process of finding out where it might lead, if in fact it leads anywhere. And there's some interesting, perhaps some things to think about there. I guess the two cases that you've talked about are really interesting, sort of like crash together, aren't they? Because they kind of show both sides of the problem in different ways, or both sides of the issue in different ways. I would see it as a problem, but others might not. I think Privacy International is a wonderful case on sort of the perils of the kind of highly legalistic approach to constitutional law and the absolute chaos of the 18 different invented limitations on jurisdiction that they are coming up with between them. Whether it is almost impossible to understand that case, isn't it? I mean, as you say, there are some bad decisions from the UK Supreme Court in terms of comprehensibility in recent years. This is like possibly a new high or low, depending on which way you would put it.
It gives us something to talk about for another 50 years. That's my theory.
It does. It's up to. this has got nothing to do with anything serious, but I was reading that case when I got to an exam board in Aberdeen, and I was in a coffee shop and it was giving me such a headache, and about half an hour later I looked up and realised I hadn't had the sandwich I'd ordered, and went over to the thing and said, why haven't I had my sandwich? And she said, it is literally there, it's been sitting next to you there for 30 minutes and you haven't even looked at it, because this case was absolutely destroyed my brain. I had no capacity to see beyond the thing, and obviously I looked like a complete imbecile, and I'll never go back to Aberdeen again as a result. But that's how difficult this case is, and I guess it is one of the challenges of this new kind of we can define the principles as we like approach, which I think is probably underpinning the majority. But then that's nice in the sense that it helps them work out what result they want to achieve, but it means there's an awful lot of difficult and torturous work to do in terms of how they get to that point in terms of justifying it and linking it back to the kind of the more hard legal sources. So I think that's one of the really interesting things about Privacy International for me. I think the complexity of the case is a consequence of the sort of the intellectual sort of paucity of the new approach in some ways. I think on the other side, and of course that's a 4-3, it's a split, it's completely divided, and if we're at a kind of constitutional crossroads, then the idea that we're just passing these very difficult decisions to basically to be decided by a flip of a coin between 7 randomly chosen judges in the Supreme Court is to me highly problematic. And you wouldn't want to overestimate how often they do come down to that split decision, but there's a number of cases where there have been some serious, you can think of Evans, you can think of yeah. So that to me is interesting. On the other side, then you've got which in some ways I'm more sanguine about, but also more interested in, is the Cherry Miller thing, which I agree with you. I mean, you can absolutely see why they were tempted into getting involved here, and it's hard to kind of be too critical of that in the moment and in the spotlight and bearing in mind the extreme conduct of a minority government that had effectively shut the legislature down. But then you have the opposite of the kind of the capturing of not just the rise of legalism in Privacy International, but then the capturing of the more political constitutional principles like parliamentary accountability in particular. And I think that also seems to be concerning, especially done, and I appreciate this is, they can never win, but we've just criticised them for having a 4-3 split. The 11-0 also looks deeply problematic as well, because then you're shutting down any possibility of dissent, discussion, alternative perspectives. It is just the sort of the uniform view of the court. And both of those have real problems. And I think the fact that they are both problematic suggests to me that this is not a very good mechanism for whether it's a good mechanism or not for making these fundamental decisions. It's certainly not a good mechanism for trying to work out and refresh the structures of our constitution more generally, which I think is exactly what's going on here. Reflection, as you say, about the constitutional structures, whether it's through doctrines like constitutional statutes or instruments, or redefining the kind of the fashions of judicial reasoning from principle as well. So I think there's quite a lot on either of those things in different ways I would see to worry about. But perhaps the really interesting thing, I think, is someone who's sort of always been very attracted to like the political constitutionalist analysis of the UK's constitution, is thinking about if this is happening, and it's tedious people like me can go, oh, they've got it wrong, they shouldn't be doing this case is wrongly decided, they're going too far. Well, they don't care what people like me think, and that's fine, nor really should they. But the question is then, what happens to the sort of the political dimensions of the constitution if the court becomes the kind of the leading actor? And I think that's where the future is still very much unwritten. I mean, I think clearly it manifests, the political stuff though, obviously manifests itself in the context in which the court's acting. I mean, it's very difficult to, the prorogation case, they are basically incited into overreaching by an executive overreaching as well. And I think the context goes a huge way to explaining that decision. It would be really interesting to see now in the new era of or the normal service of a majority government, whether they are prepared to overreach in similar ways, whether they will fulfil the kind of the promise of we will be a check on majoritarianism, or whether it's easy to 11-0 hit a weak government while they're on their knees, and it's much more difficult to kind of find ways to intervene against Parliament and government united. So that will be interesting to see. I think the other thing, perhaps, is also what, as you alluded to, there's obviously challenges for them in terms of the way they navigate the differences within the court, but also what about the kind of the constraints that may emerge? So if traditionally the courts have kind of constrained themselves in some ways, not naturally going near the royal prerogative, which they give up in the prorogation case, not naturally going against the intention of Parliament as expressed in statute, as they seem to be pushing it back against in Privacy International and other cases as well. like Evans, well, what new constraints might emerge, whether internal within the court, or which we'll never really know about, because this is all completely confidential, isn't it? We're not going to find out what the splits in the court are. But more interestingly, the kind of, well, what political reactions might come from. The most obvious question is about the government and Parliament, and whether anything will come of Boris Johnson's Democracy, Rights and Constitution Commission, which people will have different views about how worrying and dangerous that is going to be, or whether it'll just get bored and it'll all crash to nothing on the sort of the rocks of the day-to-day politics in a year or so's time. But also thinking about if the courts are now saying, here we are, we're going to get involved in politics a little bit more, or that's the impression that they're giving, well, then they're going to be asked to decide more and more difficult things that they might not previously have wanted to go anywhere near. So are they going to end up deciding some sort of litigation around whether the Scottish Parliament has the power to legislate for an independence referendum? They don't want any part of devolution in that sense in the first Miller case, do they? When they say, oh, the Sewell Convention doesn't give the devolved assemblies any right of consent here. I don't. If they get that case, I don't see how they can resolve it in a way which keeps everybody happy.
Yeah.
It's impossible, isn't it? Basically, you're going to annoy somebody somewhere. So, do they really want the kind of attention that goes with that? And they seem to have missed opportunities in cases like Privacy International, but probably more obviously in Terry Miller, to kind of come back to some sort of doctrine of non-justiciability. They don't really, unlike the divisional court, they don't seem to want anything to do with that. So they're probably going to be pulled into they could be pulled into difficult territory. Also, I think your example of Section 26 of the Withdrawal Agreement Act is really interesting as well, because I absolutely see the separation of powers critique of the means through which that power is going to be delivered. The idea that the government is taking a power to direct the courts through secondary legislation on matters of this significance in vague terms is just insane. I mean, it's absolutely wrong. But the really interesting thing is, I think the courts have probably struggled in that case and in prior stuff around the Withdrawal Act to articulate clearly why their dissatisfaction with kind of their role not being adequately set out, not being adequately explained. The Lord Neuberger stuff where they were saying, well, we need sufficient direction as a Supreme Court if we're going to be the ones deciding where retained EU law doesn't apply. We want direction there because we know that's politically treacherous water. And I think the same thing will be true of the lower courts in relation to Clause 26. When they're embracing difficult, controversial political cases in other areas, it becomes more difficult for them to say, no, we don't want this power. We don't want the power to decide whether to depart from CJU judgments. Actually the power. So I can see the critique of the means of that, but I think their current direction of travel makes it much less difficult for them to step back from the actual substantive power, if it ever comes, to play a role in sort of defining which part of retained law will and won't be kept. And again, that's got the potential to be controversial. So I suppose the ultimate question then is not just about the reaction to the court from the political branches and the court's own reaction to challenges it will now come, but also sort of about the popular reaction to the court as well. I mean, we're in a moment of sort of the Supreme Court under Lady Hale was sort of riding high in public opinion, and it will be interesting to see will that last? Will the prominence of the court, now it's sort of encroached to some extent on these more political issues, is the kind of impartiality of the court going to be challenged, not from politicians also, but just from kind of in the public realm more generally, in popular culture? And I think that brings me back to the point, the criticisms I would make before, which you sort of already explained, is this really an accessible way for constitution making to go about? Because we can sit here in this room and say, oh well, the court is making fundamental changes to our constitution, and I think they are. But so far as there is engagement more generally with the idea of the Supreme Court changing, it's a very superficial kind of, we've got a new court, we've got the president wears brooches, they told Boris Johnson to get out of here, and that doesn't strike me as a very satisfactory basis for kind of thinking about a very flawed constitution of ours that we might want to reform. It worries me that that's a big part of the furniture. So where I would take a different view to the Judicial Power Project stuff is while I'm very concerned about the court kind of self-ascribing these powers to itself, taking this constitutional authorship role. Whereas they, I think, and Boris Johnson and the government are talking about constitutional restoration. Let's take it back we need to go back to the way it was before, that was great.
Yeah.
Courts have just got out and then everything's fine.
Yeah.
Actually, I think what I'm more worried about is whether whether the court's sort of imposition of itself at the centre of our constitutional life creates barriers to a change in the constitution for the future. In other words, whether effectively now we've accepted we've got a constitutional court and all we need to go with it is like a codified constitution which kind of captures the roughly flawed status quo in a very unimaginative way. And that's the constitutional reform debate we have for the next 10 years. There's Keir Starmer in the Labour leadership thing was sort of, I was reading the comments of his thing, of his constitution pitch, which is sort of we need federalism, and he's written constitutions in there as well, and that, I don't know. I'm interested to think about how far that lack of imagination in political terms of constitutional reform is connected to the kind of the simplicity of kind of just saying, oh well, the court deals with the constitution, that's fine, it's much better that way, it's safer. So those aren't really a connected set of thoughts or questions, but I think there's a huge amount to think about here, and I think it's really important that you are identifying the way in which these patterns of constitutional change are developing. And I guess the next thing to think about is what cases will we get next? As you were saying, and how far will this pattern continue to be generated? What do we do about it if we are worried? I don't know. Thanks.
Thank you.
Thanks, Mike. Do you want to comment on that, or should we open the floor for the questions?
Well, there's lots I could say, but why don't you file lots of questions and we'll have a discussion and we'll take it from there. That would be really great, and then I can answer your questions and some of Mike's comments as well at the same time. So we'll do it that way. Or you can all be silent and I'll reply to Mike.
Shall we collect a couple? Any? Yeah, please.
That was so interesting, thank you. I think you might both allude to this, and I apologise if I'm horribly oversimplifying it, but do you think that the linguistic or maybe interpretive acrobatics that some of the Supreme Court justices are engaging in, especially in something like Privacy International, is actually just a justification or perhaps at worst a cover for a progressive move towards political activism?
Thank you.